We have to continue from here. So that is social responsibility and accountability. So as we have already discussed, always responsibility and accountability go hand in hand. So why there should be the imposition of corporate social responsibility, and then why we have to be taking the accountability also. So the various issues that are related with these two are: first thing is mainly to protect the interests of the shareholders, stakeholders. So in the stakeholders, it is a wide concept which is going to cover all these categories of the people below. So it comes like employees, shareholders, creditors, competitors, the government, all the related people together are called as stakeholders. So first thing, the first aim to implement the CSR is mainly to promote the interests of all the stakeholders. Then next one is to promote the common welfare programs. So in the society, there are so many things that are pending, and because of the lack of development and lack of funds also, the economies are lagging behind. So to implement certain programs which would be beneficial for the society and the economy as well, this is an important concept which has been implemented. So apart from that, the various programs that are taken up as a part of the CSR activities are eye care programs, then seeing to it that the drug addiction is being stopped, and then quit the smoking also. So these are the various incentives that are taken. And then, as I said, always the responsibility and then accountability uh, go together. So we have to see to it that we change the kind of profile that is existing for our country. So we have to make changes in the ownership, and then we have to see to it that more investment is flowing into our country, and then we are going to see to it that there are more allotment of shares to the promoters also. With that, we can have more development in our country. And then always our country and the corporates should be sticking to the rules and regulations that need to be implemented. And then last one is, if we are going to have the social responsibility, then ultimately it is going to improve the quality of work life, and then it is going to give us more quality in the employment opportunities and ensure that wages are also given properly. And then it enhances the security also. So these are the various things which we can have if we are taking the responsibility, social responsibility. Then that is these are the benefits which we are going to get. Now, next one is a reflection of stakeholders' accountability in legislation. So, if the stakeholders are going to be taking the accountability, and then if there are certain laws which are going to protect the interests of the stakeholders, then what all benefits we can get actually. So, as we have studied so far, like all the people who are connected are going to be the stakeholders of the company. So now what all we are actually doing in our country or as a part of CSR, that we are giving them the protection. That is, protection is given to the stakeholders. So there have been various laws that are being implemented. So first thing is the Indian Companies Act 2013. It has made various rules and regulations for the following things, like how the board of directors should be drafted, what all various committees should be drafted in an organization, and what should be the powers and responsibilities of the shareholders, and what all they have to discuss in the annual meeting, and what all disclosures they need to do when it comes to the financial statements. So all this list has been given by the Companies Act. And apart from that, the Ministry of Corporate Affairs also has given certain rules and circulars and guidelines which need to be taken up by the companies when they are administering. And the ministry has also issued the national guidelines, so that all the business enterprises are going to take up these guidelines, and then they are adhering to these guidelines. Then, apart from this, all the listed companies in our country are being regulated by SEBI, and even SEBI has also given certain regulatory framework as well as the rules and regulations. Apart from SEBI, if we have to check, then RBI and IRDA, Insurance Regulatory Development Authority, they also have prescribed certain norms for the governance of the corporates. And then, because of certain things that are happening in our country, like because of the malpractices or because of the bankruptcies in maximum number of companies that were taking place in our country, the the government has come up with these acts also. So that is Insolvency and Bankruptcy Code. So which, and then apart from that, one more thing that they have implemented is Prevention of Money Laundering Act. So these are basically necessary to be implemented because all these corporate entities are indulging in certain fraudulent activities, which in turn are going to turn out to be huge loss for our economy. So that's why these codes and these acts have been implemented in our country. So that is with respect to the responsibility. Now moving ahead. So one more thing is, like yesterday we have discussed this one. No? One more thing is guidelines on the shareholders and stakeholders interest. So what all guidelines have been given by our corporate system? So first thing is, whenever the companies are following this CSR, at that time, apart from the CSR activities, all the companies should see to it that it is going to provide certain protection to the stakeholders. So for this protection of the stakeholders interests, various acts has been enacted, and apart from that various acts, the Organization for Economic Cooperation and Development has published a report on the corporate governance, like how the companies or the business entities have to improvise their rules or regulations with respect to the protection of the stakeholders interest. And apart from that, the various organizations from the UK institutional investors Hermes have also published the Hermes principles, which has given what kind of relationship the company has to have with the stakeholders, so that in the long run the stakeholders are also going to be satisfied and the company is also going to get benefit with the association of the stakeholders. So you have to basically maximize the shareholders value, and then you have to see to it that they are going to be attached with the company for a long run. Then only there will be prosperity in the business organization. So basically this stakeholders guidelines that are being given by the various acts says that emphasis on main things, that is you have to retain, the company has to retain all the stakeholders for a long term. Then they have to see to it that they are generating value for the shareholders. So how many shares they have held, for all those shares the value should be increased. So when the value will be increased, only when the company is following all the rules and regulations and it is providing quality goods and services and it is following the ethical practices, then only in the long run the company will have certain benefits. So that also should be kept in mind by the companies, and then it has to maintain in the long run all the relationships with the stakeholders. And mostly whenever they are going to take up any policies or any strategies in the organization, then also it should be a stakeholder oriented approach. So they have to see what are the interests of the stakeholders, and in that way they have to work, keeping in mind the organizational views also. So it has to see to it that it is maximizing the profits as well as it is going to maximize the returns for the stakeholders also. And apart from these aspects, the companies have to concentrate on the various issues like the environmental, social, and the governance aspects that are related to the company, and it has to maintain the stakeholders' accountability. So this is the various guidelines that have been issued. Now next one is in the material they have given all these accounting standards. Just you can give a look of these accounting standards later on. So yesterday we have discussed like the implementation of financial in the financial statements. When we are going to disclose our financial information, then it should be according to the accounting standards, isn't it? So for our country, we are having Indian accounting standards given by ICAI. And when we are dealing with the international businesses, we are going to take up India international accounting standards, as well as we are going to keep in mind IFRS. So these are the various standards that has been listed out. So when the companies are going to disclose its financial statements, it has to see to it that all these standards are being taken up properly and the disclosure requirements related to these standards are being met. So you have IFRS as well as international accounting standards. and Indian accounting standards. So these are the IASEs here with respect to our country. So our Indian accounting standards list has been given here. So all these accounting standards need to be checked by the corporates when they are going to implement anything, as well as when they are going to disclose the financial information. That information should be disclosed according to the standards only. Then only our financial reporting system will be considered as a good financial reporting system, and then only the auditor will actually check our financial statements also. He will not give any negative report. Then next one. So that accounting standards you can just go through later on. Now coming to the important topic of structural framework of corporate governance. So how actually the corporate governance system will be working in the corporates. So now this is very important topic also. Yes. So board of directors. So when we say the board, often whenever we are talking about any meetings or anything, we often hear the name board, isn't it? So what does actually the board consist of? So in the common parlance, in the company act terminology, whenever we are saying it is the board, so that means it is the board of directors as per the company law we are talking about. So the board of directors means basically a group of people who are deputed and who are being elected by the shareholders. So these are the people who are actually taking up any decisions, who are taking the authority for the enterprise, and they are going to be a part and parcel of the organization. So whenever it comes to any kind of implementation of any policies, any strategies need to be made, any decision need to be taken for the enterprise, these board of directors are going to work collectively. So basically these board of directors are going to be elected by the shareholders, and then these people are going to be associated with the organization, and they are going to be a part of the organization, and they are going to see to it that whatever is the motive of the organization, what it wanted to achieve, what it wanted to achieve in the long run, and how it is going to maximize its profits, or how it is going to reach out to the consumers and to the stakeholders, all these are being implemented by the view and vision of the directors only. So if the directors are taking the decisions in the right direction, then probably the companies can get maximum benefit out of their decision making also. So these people are basically a team of the people or a group of people who has been elected by the shareholders. And then the head of the board of directors is going to be generally the chairman. He is going to act on the behalf of the board, and then we will have in the board of directors, it is a composition of the independent directors, executive directors, non-executive directors. So all these people take it together, we are going to have the board of directors. And this board of directors, as I said, they are the central part of the organization, because based upon their decisions only the company is going to work. So they are going to be a part of decision making, as well as they are going to be a part of the governance system in the company also. And whenever they are taking any decision, they have to see to it that their decision making or their decision is going to have a positive impact on the organization, and whatever decision they have taken, whether it is going to give any positive impact or negative impact, ultimately they have to be responsible for their decisions or for their actions. So always there is a legal imposition on the board of directors, and for whatever action they have taken, later on they cannot deny such obligations also. So that's why when they are taking up any decision or they are coming up with any policy, they have to be responsible for that. So now moving to the important one, the types of directors. So in a company, generally what all types of directors we can see. First one is ordinary directors. So ordinary directors are also referred as a simple directors. So basically these are the people who are going to attend the board meeting, and then they are going to participate in the meetings of the board also. So just they are not going to be either the whole time directors nor they are going to be the managing directors, but simply they are going to attend the board meetings. So much of the execution part and all, it is not imposed on them, but still they are a part and parcel of the board. Now next one is managing director. So managing director is the person or any person who has been elected by passing a resolution by the company, and then this resolution will be generally passed in the general meeting, and in the memorandum and in the articles of association, what all rights this managing director is going to have, that will be listed, and he has to act according to that only. Then next one is executive director. So as the name suggests, these are the directors who are going to be performing the tasks whatever are given to them. So basically they are more into the execution of the tasks, and then they are going to complete the things. So they require a regular service towards the organization. So whenever some decisions need to be taken, some policies are need to be framed, these executive directors are going to be a part and parcel. So maximum these executive directors have the maximum involvement in the management. And then sometimes the employee can also become the executive director, but he can become an executive director only if the articles are going to permit him. Then only the employee can become the executive director. Then next one, non-executive director. So non-executive director, they are not into the execution part. They are just going to have their involvement in the governance of the company. So when the company has taken up any policies, or when the company is going to implement any strategies, at the time these non-executive directors are going to be a part of that. They are going to see to it how these things are being governed, how the things are being taken up by the company, and whether the company is managing its affairs in a proper manner or not. So mostly they are involved in the governance part only, not in the execution part. Then next one, shadow director. This is also one important term. So shadow director is basically a person who is responsible for the entire direction of the company affairs. So like how our shadow will be there entirely throughoutly with us. So in the same manner, even with the organization also, the shadow director is going to be attached, and then basically this shadow director is going to give certain directions to the directors, and whatever directions he have given, the board is going to implement that. So probably this person is going to be a person who is having lot of knowledge and who is having more awareness regarding the company's management. So basically the board of directors are going to take the inputs from this person, and then they are going to implement the things in the organization. So on the person on whose directions the board is going to work is called as a shadow director. Then next one, additional directors. So additional directors are going to be appointed between 2 annual general meetings, and if in the articles of association, if it is being given, then only these additional directors will be appointed. But we have to see to it that when we are going to appoint the additional directors, these additional directors are not going to exceed the maximum strength of board of directors. So suppose the board of directors totally we have to have 15 members. So the with inclusion of the additional directors, the board should be 15. So 13 other directors like executive, non-executive, independent, plus 2 additional. So totally your board will be comprising of 15 directors only. So like that we have to manage. The additional directors should not be exceeding the maximum strength that has been decided by the board, and that is being specified in the articles of association also. The next one is alternative director. Alternate director. So this is very simple one. So alternate director is any person who has been appointed by the board, and then even when they are appointing, it has to be authorized by the articles, and then resolution has to be passed. So only when the original director of the company is not available in the organization, then only the alternate director is being appointed. So as I said, when we are going to appoint the alternate director, it has to be authorized by the articles, and then till the time the original director is going to come into his service back, the alternate director will be taking up the responsibilities of the original director. Then next, professional directors. So as the name suggests, professional director is any person who is possessing the professional qualifications. So he might be expert in certain things. So because of his profession, so he might be a expert of legal things or company laws or something like that. So whenever he is having any professional qualification and then he is becoming a director, then he will be called as a professional director. Then next one is nominee director. So nominee director is basically one director is being nominated by somebody else. So who can be the somebody else? Sometimes the banks or the financial institutions are going to nominate a person as their representative in the board. So whosoever name has been proposed by the financial institutions to the board, that person is called as a nominee director. Suppose ICICI Bank is proposing my name as a part of the board of directors, then I will become the nominee director. So why these financial institutions are basically involving in this is, suppose the company has taken any loan, and then the company is defaulting in the loan. The company is not paying back the loan. At the time, these banks or the financial institutions will interfere in the company's affairs. So to know what is the actual financial status, and then to know when the company can be able to pay the loan taken from these financial institutions, at that time only generally these banks or financial institutions will nominate one person to be a part of the company's management, so that they can know what is exactly happening in the organization, basically related to the matters of the financing. So then generally these nominee directors come into pictures. Then coming to the independent director. So in the last classes also we have discussed independent directors. So independent directors are the people or the person who is acting independently. So he is not going to be under the control of the management. He is able to take his decisions independently. That person will be called as an independent director. So why we should have an independent director is, if that member is being influenced by the board, then probably it would be the personal benefit of the organization. So to keep in mind the stakeholders' interests and see to it that all the people whoever are connected with the enterprise are going to get some benefit, then for that purpose only generally independent directors are being appointed. And then we have to see to it that they are really independent. They are away from the influence. And then lastly, coming to this, women directors. So the Companies Act 2013 according to this section 149, it has said whether it is going to be a private company or public company, at least one woman director should be there in if the company is going to satisfy the following criteria. So if the company is going to meet the below criteria, then definitely at least one woman director should be there. So first thing is, if the company is a listed company. So if you have been listed on the stock exchanges, then definitely you should have one woman director. And then next one is, securities are listed on a stock exchange. So your shares are being traded on a stock exchange. Then also you should have an woman director. That means the company should have an woman director. And then lastly, if the company's paid up capital is 100 crores or more, or the turnover of the company is 300 crores or more, then also woman director should be appointed. Next one, residential director. So residential director is as per our taxation norms. So we have a resident, non-resident, no? So in the same manner, whenever one person is going to stay in our country for a total period of not less than 182 days in the previous year calendar, then that person is called as a residential director. Then coming to the last one, so that is small shareholders director. So one of in the earlier classes also we have discussed small shareholders. So small shareholders are basically the people who are going to have the shareholding in a very nominal account. So on the other day also I said maximum number of policies are being framed to give the benefit to the people who are holding maximum number of shares. So at the time the small shareholders interests are going to suffer. To give the protection to the small shareholders also, this small shareholders director is going to be appointed, and then he is going to safeguard the interests of the small shareholders. So we can appoint one single director if at all, if it is a listed company. And then the next one, minimum and maximum number of directors in a company. So how many directors should be there? So according to section 149 of the Companies Act, it requires that if at all, if it is a public limited company, then minimum number of directors should be 3. So we are talking about the minimum number. And if it is in case of a private limited company, then the number of directors minimum to be appointed are 2. And if it is a one-person company, then at least one director should be there. So these are the minimum requirements which all the companies have to compulsorily abide. Now, the maximum number can be up to 15. So maximum 15 directors can be there in the organizations. And more than that, if we want to appoint, then we have to call a general meeting. And in that general meeting, we have to pass a special resolution. Then only we can increase the number of directors. So these are the minimum and the maximum requirements. And then whenever it comes to the directorship, then one person can hold up to 20 number of directorships only. So he can be a director for at least only up to 20 companies. Then next is scope of board of directors. So what all things the board of directors can do and what all powers they are actually having. So first thing is, so whenever the board is going to comprise of, then at the time the board should have a combination of executive directors and non-executive directors. So in that again the percentage should be 50. So 50 executive and 50 non-executive should be there. And in the total number of board again, there should be independent directors also. And at least 1/3 of the board members should be independent directors. So if our total strength of directors are going to be 15, in that 1/3 members are going to be independent directors. Then remaining people can be there like executive directors, non-executive directors, women directors, depending upon the type of the company we can have. Then next one, So just now we have discussed no nominee director. So this nominee director is related to the second point only. You can see there like financial institutions generally, as I said, financial institutions are basically going to propose one person's name as a nominee director. So as per the actual company's act, financial institutions should not interfere or they do not have any role in managing the company. So only whenever the company is defaulting in the loan taken by the company, then only the financial institutions can involve and they can nominate a nominee director here. In case everything is going smoothly, then there will not be any necessity of the nominee director. So just in case of because the company is not paying the loan taken by it, so in such cases only to protect the shareholders' interests and to know the financial status, the financial institutions are going to nominate one person as a nominee director. Then next one. So now coming to the chairman's role. So the chairman is going to be the head of this board. So how one chief executive director is going to execute all the things in the same manner, the chairman also is going to conduct. And if there is any non-executive chairman, then also he is entitled to maintain the chairman's office at the expense of the company. Then next one is with respect to the number of committees that one director can be a part. So if a director is there, then he can be a member of maximum 10 committees, or he can act as a chairman for maximum of 5 committees only. So this number has been imposed on these directors so that they are going to be free and then they can actually indulge fully in the companies where they are becoming the director. If more number of companies they are being involved, then probably the decision making is going to suffer. So that's why they have imposed certain restrictions, like a director should not be a member in more than 10 committees. Then now coming to the role. So the role of the board of directors. So actually what role they have to play, what all they have to see and what all they have to implement. So the role of the board of directors has been given by the Ministry of Corporate Affairs. So these are the basic role which the board of directors has to play in the company. So first thing is they are going to be a part of the oversight of the business. So whenever you are running the business, the board of directors have to monitor, they have to measure how the management is working, and then appropriately they have to reward the management also. And apart from that, the board of directors have to see to it that the company is following the legal framework. That means it is going to follow all the rules and regulations stated by the statute, and then it is going to maintain an integrity of financial and reporting systems also. That means it is going to, the company is going to give the entire financial information to the stakeholders, whatever is necessary, and then it is going to generate proper reports also. Financial reports are also being prepared and they are timely disclosed. So that is the first main function that the board has to do. Then next one is the board is having an responsibility towards the judgment. That means whenever the board has to take any decision, at the time they have to keep in mind the interests of the company as well as the interests of the stakeholders. The board has to see to it that neither of the parties are going to suffer, and whatever decision they are going to take, that should be in accordance with the legal statutes, and then it is giving the protection to the company as well as to the stakeholders. And then whatever are the norms that need to be followed by the company, all that norms should be taken care by the board. The board has to take an active part in the decision making, and when it comes to the division of authority, it has to give the division of authority, it has to decentralize, and then it has to specify what all roles should be played by whom, and then monitoring of the management also should be done, and then lastly it has to give importance to the company as well as to the shareholders also. And then the last point says, like, whenever the company is going to be framed and the board of directors are being appointed, then at that time the board of directors has to check that the company is following the basic framework. So how the acts require the companies to work, whether the company is working in the same manner or not, we have to check. And then we have to see whether we are going to follow the law framework. As I said, we have to see whether we are going to follow all the rules and regulations, and then see to it that we are going to act in the interest of the company and as well as in the interest of the stakeholders. These things the board has to take care of. Next, functions of the board. So what all it has to take up, what all activities it has to take up. First thing is governance. So it is the governing body. It has to see to it that everything in the organization is taken up smoothly, and every part and parcel of the organization is being decentralized. It is, everybody knows what role they have to play, what responsibilities they have. So everything in the governing part of the company, the board of directors should be involved from the starting till the end of the, or till the end of the task. The governance should be smooth. So in that way, they have to check what are the rules, regulations, what all systems they need to follow, and then see to it whether the company is preparing the financial reports, going for the audits, and then all the contracts that the company is going to enter, whether they are legal, and then how the company is going to maintain the relationship with the employees, and what all how many members are there connected to the organization. All the members and even the stakeholders are going to be protected. So all this governance and monitoring is being taken up by the board of directors. The next one is strategic direction. So strategic direction is whenever they are going to take up any decision, they have to see to it that the decision is moving in the right manner. They are having certain policies or strategies based upon which they are going to take up a correct decision or taking a correct action. So when the board is going to take any decision that is related to the organization, they have to see to it that proper decisions are taken by the board, and these decisions are actually helpful for the overall growth of the organization in the long run, because we have set up the organization and we are assuming that it is having a perpetual succession. So that's why we have to think, or we have to plan for a long run only. We have to see to it that the company is going to move on, and then that kind of decision making only we should be having. And then when it comes to the workers and all, we have to see to it that all the workers are skilled, and then they are able to make our enterprise a successful enterprise because of their work. The next one, accountability. So definitely, if the board is going to take accountability, and if it is going to take good decisions, and then if it is going to take the responsibility, then only the growth of the company can be seen. So the main thing that the board has to do is the board should be taking the accountability and responsibility for the actions taken by them, or for the policies framed by them, or for the steps which they are going to implement in the organization. So as I said earlier also, whether it is going to be a positive result or negative result, the board has to take the responsibility. Now going to the powers. So what all powers the board of directors are going to have? So first thing is the board of directors will have the powers only as per the provisions of the act. So in the act, what all powers have been given to them, only till that powers only their purview is going to be there. So beyond that, if they are going to act, then the law will not give them any protection. So the board of directors are always subject to the provisions that are contained in the act. So in the memorandum and in the articles of association, what all powers and what all duties has been listed out, they have to abide by them. Then next one says, no regulation made by the company in the general meeting shall invalidate any prior act of the board. That means what if already the board of directors have taken any act, and now if they are not going to take any responsibility for that, or if they are not, if they are going by that also, it will not invalidate. So whatever action the board of directors have taken, that is going to be binding upon them. Then next, these are the various powers that have been given to them. So first thing is they are having a power to call the shareholders, to make calls on the shareholder. So if any unpaid shares are there, then they can call them and then ask them for the payment of these shares. Then they can authorize the buyback of securities. The next one is they can issue any securities or debentures within our country or outside the country also. They can borrow money for the company, not in the personal capacity. So anything, all these activities, they can be indulged in only with respect to the company only. They can invest in the funds of the company. So that investment also should be in the interest of the company only. They can grant loans or they can give guarantee also, and then they have to approve the financial statements and they have to give the board report also. So before uploading them on the website and all, first they need to check and then they have to approve the statements. Then if they have the sufficient profits, then they can think of diversifying the business, they can expand the business, and then the board of directors can give the approval for amalgamation, mergers, or reconstruction. So here reconstruction could be internal reconstruction or external reconstruction. And then whenever the company is going to take over or acquire any other stake in another company, for that also approval can be coming from the side of the board of directors, and any other matter that has been prescribed for which they have been given the legal powers, all that powers they are given and then they can enforce them in the company. So these are the general powers. And then at the same time, when they have been given these powers, there are certain restrictions or certain conditions that are imposed on the board of directors. So always they have to act within the conditions or the restrictions only. Beyond that, they cannot exercise their power. Now we have various models. So certain models are being developed for good governance. So depending upon the convenience of the company, these are the various models that could be adopted. So first one is the traditional or the structural model. So basically this is the oldest model that is being existing. And if we look at this model also, some time we may feel that it is outdated by today's standard, or because of the changing environment, we may not take this model to be suitably implemented for all the organizations. But even though it is a bit outdated also, this model has given various important inputs, and these inputs are still followed by many of the corporates till now. So this is one of the very useful model. And as per this model basically focuses on the board of directors. So how one board should be formed, and then what all kinds of decisions they can take as a part of the board, and when they are holding any meetings, at the time what all norms need to be followed by the board, and what will be the approved structure and format that need to be adopted by the board of directors in the organization has been given by this traditional model only. So as I said, even though it is outdated, but as a this has given valuable inputs on the board. So whatever inputs has been given by this model, no, still maximum number of companies are taking this as the foundation. So apart from this, they have given like the various responsibilities that one board is going to have is also being listed. So first thing that this model has said is that whenever it is a CEO and the management, like what all they have to take up in the organization, and how the chief executive officer should be, and how the management should be working, that responsibilities and how you have to delegate the authority to them, that is also given. And then next one is how the board committees should be framed. So in the other class also we have seen various committees, isn't it? So we have seen audit committee, board committee and all. So like that, when you are drafting the board committee, in your board committee, what is going to be the composition of the committee? So just now we have seen the committee will be consisting, the board will be consisting of independent directors, executive directors, non-executive directors, like that. So when you are framing with your board committee, what all members should be taken as a part of this board is also given by this traditional model. So as I said, valuable inputs have been given by this, and this model has also given us uh, an insight on the accountability and communication of the policies that need to be done from the side of the board to the stakeholders. So that is what this model has discussed. Then next model is Carver board governance model. So this model has mainly given emphasis on the ends of the organization. So basically, once when we are setting up any organization, what is the end point of the organization? That means what is the main motive of the organization? So maximum organizations run with the profit maximization or profit motive. So this model says when you know what is your aim, you focus on the you focus on your aim. So how you can achieve your main target? You have to work in that manner only. So whatever works you are assigning, whatever policies you are framing, and whatever governance system you are going to take up in the organization, all that need to focus on the maximum aim of the organization and how we have to achieve that. What all we have to take up so that we are going to get our ultimate result. So that has been discussed in this model. And then what all the board should take up the responsibilities, and how the CEO is going to act in an organization, so that he is going to see to it that what is the main target of the organization that is going to be achieved. So for that purpose, we have to create the policies, and all these policies the board has to implement. The next one is Cortex board governance model. So this model says, like, when we want to prosper in the economy, then we have to focus more on the values of the organization. So if we are going to maximize our values, then we will be in a position to create more goodwill, and then the community will automatically know about our organization, and there could be more growth for our organization in the future. So this model basically focuses on the values of the organization and how your organization is going to bring some positive impact on the community. So again, this model has given the various insights on what all the board should focus on. So your board of directors has to focus upon the what, so that they can enhance more values. So first thing is, they said, like, there should be a good relationship that is existing between the customers or the clients, and then even in the marketplaces also, we have to see to it that our we are going to establish our organization, and we have to take up the best practices which are followed in the organization, and then we have to see to it that the employees are having the maximum profit. Yes, then then again, it has given an emphasis on what all standards one company need to follow, what will be the general expectations of the company, and for that how we are performing in the organization, so that whatever is our, again, our aim or our growth or our values, that we are going to meet. So that is this basic cortex model. This emphasis mainly, this emphasis on, it is on values. Then next one, consensus board governance model. So this consensus model, or it is also called as process model. So it is more of a cooperative model wherein maximum it is used by non-profit organizations. So even some organizations, other organizations also follow. So in this model, if the board of directors are there, how the board should be working, that particular aspect is being discussed. So all the board members, first thing is they should give the equal voting rights, and then they have to get equal responsibility and equal liability. Then only probably they would be working in a better manner. That's what this model says. And then um, this also recognizes, like, if in this board, if maximum people are having various expertises, or if they are having much of the knowledge, or which or if they are having more of the wisdom, then it could be more easier for governance, and it would be more advantageous to the organization. And then again, apart from that, if there are any difference of opinions or any concerns are being raised, that means any disputes or any grievances are there, so how it should be handled, what all agreements should be drafted, that is also being given from this model. And then the last model is competency board governance model. So competency model mainly focuses on the communication and the trust principles. So if we are more of communicative, and if we are going to establish more trust in our relationships, then probably the entire performance of the board can be improved. So this is basically a model wherein they are going to have more emphasis laid on the relationships and then communication. So because we have to be competent with each other, we have to go hand in hand. So that's why all the people should be properly communicating, so that if there are any disparities that are coming in between the people, if there are any disputes that are cropping up also, that could be solved very easily. And then the other points as per this model are, like, whenever they are going for any practices, so they have to adopt any good practice which is going to give them more values to the organization. And then if the board members are going to be more experienced persons, then probably they can bring in new reforms also. And one more thing is, whenever they are going to take up any duties, at the time they have to fully take up the duties in the fiduciary capacity or in the trusteeship capacity, then only probably that duty will be fulfilled in a better manner. So these are the 5 models. Then next one, appointment of the directors. So how the directors can be appointed. So as per the Companies Act 2013, these are the various requirements which need to be fulfilled. So first thing is, every company should have the board of directors, and then minimum number of directors just now we have discussed. So in case if it is going to be a public limited company, minimum of 3 directors should be appointed, and if it is a private limited company, 2 directors should be there, and if it is going to be a 1-person company, then at least 1 minimum director should be appointed. And then the maximum limit for the directors are 15. Then next one, if the company is a public limited company, then at least 1/3 of the total number of directors should be independent directors. So if your total board is comprising of 15 members, in that 15 members, 1/3 are going to be independent directors. And then for certain cases, the central government may also prescribe how many minimum number of independent directors could be there. And next, when it comes to the appointment of the independent director, so at that time it should be approved by the company in the general meeting. And then when they have approved this independent director, at the time an explanatory statement also should be provided to the general public. So why they have appointed so and so person, and what all his qualifications are there, and why you are choosing this person to be your independent director. So such kind of explanation should also be there, so that to the stakeholders you can give more clarity. And sometimes, as I said, the central government may also prescribe the manner or the procedure for selecting the independent directors, and what should be their qualifications and what all requirements they have to be fulfilling. That also may be given by the central government. Then next one, if in the articles of association, if there is no provision that has been made for the appointment of the first directors, then at that time, from the subscribers of the memorandum, whoever are the individuals, from them only the company can pick up anyone, and then they can depute them as the first directors of the company. And if in case it is going to be a one-person company, then whoever is the individual member, that person will be deemed to be the first director until the other directors are going to be appointed for the company. That persons are going to act as the first director. Then next one is generally whenever we are calling for the first annual general meeting for the public limited company, at the time we have to inform when would be the tentative date for the next general meeting. And at the general meeting, the first directors are going to be appointed. So here we have to disclose these facts. And then again, uh, the next one says, the next point says, like whenever an individual want to be appointed as a director of the company, then at the time first he has to apply to the company, and then after he gets the allotment of director identification number to the central government, then only he can fill in the form, and then he has to pay the fees. So like how we have the PAN number, and then we have the other mandatory numbers. So like that, if you want to become a director of the company, then definitely we have to get the director identification number. So we have to quote the number also when we are going to apply for any directorship. The next one. So when he is going to be appointed as a director, the company has to check the following things. So first thing is he is of a sound mind. So he should be competent, then only he will be appointed. And then he should not be undischarged or he should not be insolvent. That means he should not be in losses. Then he has applied to be adjudicated as an insolvent. That means already if some court case is going on against him that he is an insolvent and all, then his application will not be taken up. His application will be pending only. And then if that person has been convicted by the court, then also this person will not be appointed as a director of the company. And if this person has been given any imprisonment for less than 6 months or for a period of 5 years from the date of that sentence, then also we cannot take him as a director. Or if there are any disqualifications on the director which has been passed by the court, then also we will not be appointing him as a director. And in case if that person is having any unpaid calls in respect of the shares, then also he will be disqualified. And if he has been convicted in any offenses, then also we cannot take him as a director. And then if he is already a director of the company and he did not file any financial statements or the annual returns for a consecutive years of 3 years, or he has failed to repay any deposits taken by him, then also he will be disqualified. And then any other case that is going on against that person, then also he will be disqualified to act as a director. Then next last one is, if one person is being appointed as a director of the company, then minimum he should not be holding the directorship for maximum 20 companies. So you can be a director of maximum 20 companies only. More than that, you cannot become the director. So that is one more imposition that has been placed on these directors. So we will stop here. So tomorrow I will continue with the remuneration of the directors. Okay.
Thank you, madam.